All right, everyone. Well, welcome to today's webinar, which we are so grateful to have both our funder here, Susan, representing the Shaberg Foundation, as well as the two attorneys that contributed to the employment update for nonprofit employers in the report itself. So I have Leah and Alex here, and they are part of the Wood Rogers team, the employment team that they have over there. And so delighted to have them. We're going to dive into their portion first, and then I'm going to be following with a report review. Leah and Alex, please take it away.
Awesome. Oh, there we go. Hey, thank you so much, Esther. Well, it's super nice to be here, you guys. So thank you so much for having us. As Esther mentioned, we are employment lawyers. We are management side employment lawyers. So what that means is we represent businesses, public, private, nonprofits, and help them navigate through different employment situations, whether that's helping them with onboarding questions or navigating a performance issue or retaliation, harassment investigation, difficult termination, through severances, all the way through post-employment defense, such as, EEOC charge or a lawsuit in court. So we kind of work with employers throughout the entire life cycle, work with a lot of different nonprofits all over Virginia and actually across the country. So glad to be here. If you guys have questions, feel free to put them in the chat or raise them as we go. My colleague Alex and I are going to just kind of go through these things, give you some of our thoughts on them. You probably have a more detailed overview in the handouts in the report, but yes, so this is your opportunity to ask us any good questions you have along the way. And ask Alex all the hard ones, but I'll take the easy ones. So
sounds good. All right, if we could go to the next slide.
Do you see that on your screen, Alex?
I do.
Okay.
So the first couple things that we're going to cover, I think maybe the first couple slides pertain to things that were passed in 2025, not necessarily this new legislation, but they're still important, and the courts and us as attorneys are still navigating them and trying to figure out the parameters. So for this one in particular, back in 2025, the General Assembly passed a statute that generally expanded employer liability for tort actions by third parties, whether it be customers, patients, anything along those lines. And it's specifically for vulnerable victims. And under the new law, employers can be held liable for personal injury or wrongful death from the hands of one of their employees. Previously, the standard in Virginia was that employers could not be held liable for the actions of their employees unless they were negligently retaining that employee or negligently hired that employee. So that was a pretty constricted view. And there were many cases throughout Virginia where an employee did something wrong and a plaintiff tried to bring in the employer into a lawsuit, and courts continually struck that down. But now if your customers or your patients are within this class of victims, which includes patients of healthcare providers, infants, incapacitated persons, people with disabilities, anything along that class, then there are certain things that you'll want to keep an eye out for. I think the best way for employers to limit their risk under this law, if you as a company or a nonprofit are interacting with this class of individuals, then things like increased background checks and screenings and having strong anti-harassment / reporting mechanisms in place so that if there's any concerns about an employee acting improperly with one of these victims, that employers can move quickly and attempt to nip it in the bud.
So we, interestingly enough, we had an investigation for a client it's an assisted living facility here in Virginia, and they had a situation where they had fire alarms going off, and a resident was trying to escape from the memory ward part of the facility. And in that altercation, it kind of turned into a little bit of a physical altercation. It wasn't clear, whether it was just sort of the employee was engaged in self-defense from the action of the resident trying to escape, or but there was clearly some physical back and forth, right? And so we were kind of analyzing under the, whether we had some obligations to report and stuff like that. But one of the bigger concerns we looked at was the implication of this new law to that situation. And it was very clear that residents of an assisted living facility fell under the definition of vulnerable victims in the law. Just like if any of you operate, group homes or work with individuals with disabilities, elderly, children, maybe people experiencing homelessness, all of those individuals could fall under the definition. So we already had that element met. And then the next question was that the law kind of asks you is, did the employer have reason to know that essentially the employee could have engaged in kind of a personal injury towards this vulnerable victim? And so there's a lot that goes into that. It's not, as Alex said, you want to make sure you're doing your background checks. So you could say that you had no reason to know that this person had violent behavior in their past. But also, we had to ask questions about what kind of training did you do to your employees? Were all these employees involved? Did they learn de-escalation training and stuff like that? And so now that this creates another layer of liability for employers, almost more direct liability. So it really, in terms of operating as you move forward with this law, we're not going to have the same defenses in court to be able to say, well, we didn't really know, or there was nothing that they exhibited towards that particular person at the time. Now they have a stronger case against you. So you as a company are going to have to do those background checks, make sure you're doing training, management training, workplace violence training, make sure you have a reporting avenue so that someone who is what's deemed a vulnerable victim, that they or their family can report very easily to a supervisor on site or a human resources person or the executive director, that they can actually report misconduct or what they believe is misconduct by an employee. And that will give you the opportunity to try to respond and address it internally before facing a claim outside.
So for the next one, again, this was back in 2025, the Virginia Employment Commission changed their regulations with respect to responding to unemployment benefit inquiries. Under the previous law, there really wasn't much liability for employers not responding to various inquiries and just allowing their terminated or departed employees to receive unemployment and not necessarily get engaged. But now under the new law, all employers are required to respond within 10 calendar days of any request for information about an unemployment claim. And there's an increase in certain penalties for failing to do so. So for the first failure, it's a warning letter, second, 100, and then third, which is the big one, employers could potentially lose their appeal rights and will not be credited for any overpayments resulting from the decision. So moving forward, we've quite a few of our clients have indicated that the 10 calendar day is quite a steep deadline, and that things move through the offices, whether it's through HR or some other departments, slower than 10 days. So our best piece of advice is to work with the person responsible for the EEC claim responses and to make sure that they get to the right person at the right time, and provide some sort of guidelines on how to respond and provide all the information necessarily requested by the EEC.
Yeah, it was interesting. We had one client who in the exact same day received a warning letter and received a $100 fine. So clearly there was some disconnect at the VEC in terms of timing, or one of the letter got stuck in the mail, and then by the time the client received it, they had already issued the fine. So, something about unemployment if many of you, if you work with employment lawyers, when you're dealing with a difficult termination, you may have been told before, look, don't dispute unemployment. Like that is one of the easiest things that if somebody, you're terminating someone who's disgruntled, maybe you don't have great documentation to support it, or they feel blindsided, or they just clearly have a different perception on things, that oftentimes if somebody has some sort of income coming in while they're looking for another job, such as unemployment, they're less likely to go to a lawyer and sue you. It's when they don't have anything, any sort of income coming in. And also the Unemployment Commission, in theory, right, it makes the employees apply for other jobs to keep receiving that unemployment. So if you were to face a lawsuit by that person in the future, there's some argument that you owe lower dollars in back pay because they've mitigated their damages by receiving some unemployment offsets the damages you would owe them, as well as the faster they get a job, that's better for you when you're dealing with litigation. So in general, we often would say to people, hey, don't fight unemployment. But now if you don't respond, and it used to be perfectly fine to not respond, this could be in your future, right? A fine or even losing appeal rights. So you do need to respond now. And it's just trying to choose your words carefully in terms of how you respond. If you would, for instance, want the person to get on unemployment, but may not, but at the same time, don't want to maybe produce tons of evidence of the misconduct or things like that. So be strategic now about the way you're responding to these claims.
All right, and then I'll just quickly cover this, just to make sure that everybody's aware. If you have any minimum wage workers in your organization, from here on out, minimum wage is going to increase annually. It's already set for 2026 through 2028. And then after that, it's going to be adjusted based on inflation and a bunch of other mathematical things that I'm not entirely, know necessarily. So just keep that in mind if you have any minimum wage employees.
All right. The big one.
The big one, yeah.
You take it away, Alex. This is the big one. I'm sure we'll get tons of questions on it. So
yeah.
Please, you guys, throw us some questions.
Yeah, feel free to, interrupt me, raise your hand, put something in the comments. We'll keep an eye out for it. But so as one of the major changes in employment law in this most recent General Assembly session was this pay transparency law. So it's effective July 1st, 2026. And you can look at it as kind of a two-pronged statute. First, it prohibits employers when they're engaging in interviews, salary negotiations, any pre-employment matters from asking or seeking wage and salary history from a prospective employee. So that would include, asking on your questionnaire, what was your previous salary? What is your expected? I think you are allowed to ask what your expected salary is. However, seeking any sort of historical information is going to be prohibited. Additionally, and on that note, and I think there's actually a couple slides that they're discussing, so I'll go into detail in a second. And then just the second prong of this statute is requiring employers to post expected salaries or salary wages on any job posting. That includes internal job postings and transfers.
And so why did the legislature pass this law? Well, we have seen laws like this popping up all over the country. And even before we started seeing these state laws that prohibited employers from, generally asking about past salary information or using on that when they're setting pay or making an offer, is because relying on historical pay information can potentially create a discriminatory impact towards women and people of color. So women and people of color have historically made less money than white men. And so by basically, if you ask on your application, what did you make at your last job? And then let's say they write 40,000 and then you make the offer. Okay, well, that's great. They're going to accept this if we make an offer for 42,000, right? But then let's say a male, and that's a female employee, whereas a male employee might come along and say, oh, I made 60,000. Then you say, well, to get this guy, we're going to need to offer 62. It sounds like a logical approach, but what that does is it potentially carries forward discrimination. So many courts, even without these laws, many courts were saying you can't do that. We didn't have any courts in Virginia that had expressly said that, but we were starting to see that most courts in the country move that direction. So in general, the state of Virginia has kind of come forward and said, all right, we're going to go ahead and address that.
Yeah, and then getting into, those are all great points, and getting into the second prong here, which is requiring that employers set a salary or a salary range. We've had quite a few clients ask us, what does that mean? How do we set these ranges? The statute provides a couple ways that you can do so. So if you're going to do a range, you set the minimum and the maximum, and it must be set in good faith. And the statute provides that you can do so by having a pay scale. If you already have a pay scale in place for employees as they progress through seniority, then that would be the most logical way to go about setting a wage and salary range and just making that public. And then if you previously, prior to hiring, had allocated a budget or anything along those lines that was previously determined, you can also use that and make that public. And then the third way that you can go about this is taking a look at your employees and seeing who is similarly situated for this potential new hire, and kind of tracking out who makes what and at what position, and then setting the range based off of that.
So one thing,
Go
okay.
ahead, Leah.
No, I was to say something to be, there you might have a situation that's kind of in the gray area here. So this is one that something, everyone's gonna have different scenarios. And what someone asked me on Friday, a client basically said they were hiring for a social worker, or I think it was a case manager. And for this case manager role, they have different regions in Virginia. So they might have the Southwest region, Northern Virginia, and like the Eastern region. And they have different pay scales for each of those regions. And so they were posting for a position, I think in Southwest, somewhere in Roanoke. And so the question was, okay, well, can we just give the pay scale, like the pay ranges for the employees in Roanoke, or do I have to give the pay ranges for all the employees in those positions across the state? Because, Northern Virginia is really going to throw off my numbers here. And, we looked at the law, we basically said, look, as long as we're making a good faith disclosure, and that's what the law requires. And essentially we made we only kept it to the pay range in Roanoke because or the Southwest region, because our argument was they weren't going to exceed the Roanoke budget. So if you look at D here, you may have employees in a particular position that make 60,000, but you only in your budget for the year have, or maybe you have a grant that is funding a particular position, and the grant amount for that only is up to 52,000. And so that you're not going to be able to offer up to the total pay range of the employees in that particular position. And the big takeaway on this is that it's not just about, this law doesn't just is not aiming at just impacting your prospective employees, but a lot of this is about your current employees. So making sure that they have transparency to see, are they on the low end or the high end or in the middle of a pay scale, and giving them the opportunity, if they see you post for a job that they're in and they see that they're under 10K under the maximum, and they feel like, well, I've got a master's degree and 10 years of experience, why am I not at the max? They're going to be coming knocking on your door, right? So before you post a position moving forward, you want to do a quick review of who do we have in those positions? Why do we have their pay there? Do we need to true anybody up? Do we have people who are underpaid or overpaid, and what's our range? Because once they see the posting in that pay scale, they might be coming and asking questions. And an employee has a lawfully protected right to ask questions about their pay, as well as to discuss their pay with other employees. So I can be like, hey, Alex, what do you make? Here's what I make. Employees have a right to say that and ask those questions, and you can't inhibit them from doing so.
All right, so back to the other restriction on the Pay Transparency Act. So if you have an employee or a prospective employee who's you're interviewing or you're filing an application for, or if it's an internal transfer, employers are allowed to voluntarily disclose wage or salary history. Most of the time they would do so for the purposes of negotiating wages, saying, hey, I made this much at my last place, I'm expecting to make this much here. But that's only after an initial offer for employment has been given to them. And then importantly here, which, is pretty interesting, is that if an prospective employee does disclose their previous employment, then employers are pretty restricted on what they can do with that information. They're allowed to make a higher offer based on that new information, but they're also allowed to go back and confirm whether that's with previous employment or through some other means that what this prospective employee is telling is the truth.
And this one, I don't even know, and I'm curious if any of you want to, tell us your secret ways of doing this. But I'm curious to how you confirm past compensation. So basically, the law says that if you make an offer to somebody of 50,000, and then they come back and they say, well, I'll accept at 50, but I need 56,000 to move my family and take this job. Well, you can go higher than your initial 50. You can't go lower. I don't know who would go lower, but that would be rude.
Yeah.
But if you said, okay, well, let me call and do a reference check on the past employer and see, can you confirm that they made 56,000 or something? In theory, this law allows you to do that. I don't know many employers that do disclose that type of information. And if I were representing them, we would advise them, no, you're not, we don't want you to disclose that because you'll run into claims by the employee and all sorts of things. But it does give you that option to confirm the employee's past compensation. Potentially, maybe if they came from a government job and you knew of their pay scale, if they had a particular GS pay scale or something, you could maybe kind of look it up or through FOIA requests or something. But I think it'd be hard to do so. I saw a question.
Yeah, quick question in the chat. I'll read it out. Does this mean that checking references, we can no longer ask their current employer their current salary? We would interpret the law as yes, you were prohibited from doing so. Even though it's not necessarily asking the employer directly their previous salary, it still has the same effect of involuntarily disclosing their previous salary.
Yeah. I'd be careful about that. And a lot of this, right, is you don't want to the law doesn't want you to underpay someone who in theory should be making more, but they're just willing to take something less because of what they made out of past job. Because that gets to the place of carrying forward that historical discrimination. So really, before you post for any position, you should really say, okay, here's our pay range. Here's what we have X amount of dollars budgeted for this position. And we're going to make an offer somewhere along this spectrum of range based on their years of experience, their degrees, you name it. You pick those criteria and then you clearly articulate those in writing in some way so that you can make a good faith offer within that range based on that. So we always tell clients, never set pay based on what someone wants or someone made in the past. Really set pay based on what your range is and what you're willing to go to.
Yeah, and I would just to add on that, if you look at it strategically, you want to be setting wages based on your own needs, not necessarily somebody else's. It puts you in a stronger negotiating position. If you look at it, be like, hey, this is what we set, this is our range, and we're not budging from it. Of course, there might be situations where you have an amazing candidate and you do have to budge, but if you're going higher, then you're probably not going to be violating this law.
Yeah, and this really just gives you another takeaway of making sure you're doing pay equity audits and whatnot on a regular basis. I mean, we were just working with a client who hasn't done a pay equity audit since before COVID, and they have people hired working in the exact same position, making totally different pay ranges or pay rates. And a lot of them, their argument was, well, we didn't set this discriminatorily. We just couldn't find anyone during COVID. So in order to get them, we had to pay them $5 an hour more. And now we're stuck at that. But then we've got someone maybe who's a Black female who's working here for 15 years, making less than the recent, college grad. And so, you really have to be careful and make sure that on a regular basis, I'd say every 2 years, you're working with your HR team, like Esther or whatnot, and you're really trying to make sure that you're doing those audits. And here are the penalties. First time offense this is from the government, would be a state government, would be a $1,000 penalty. Second time is a $5,000 penalty, but you can also face a lawsuit from the employee directly. And most of the time, and if the employee wants to pursue you under you're failing to post the range, they're going to have a hard time doing it. They have to first send you written notice. You have 15 days to correct the post and add the range. And if you correct it, they're not damaged. They can't bring a lawsuit, right? So this is to prevent kind of frivolous claims. I don't know what kind of damages someone would say for actual damages.
Yeah.
We've thought a lot about this. Oh, go ahead.
Yeah, and just a quick note on that. The original bill that was given to Governor Spangsberger included both liquidated damages, which are automatic as opposed to proving damages, as well as attorney's fees. So during this process, and I think we might have said in our mid-year legal update that attorney's fees were automatic and certain other more drastic penalties were in place. But through this negotiation between the governor and the General Assembly, they settled on this 1-year statute of limitations and actual damages, which is a much more favorable outlook for employers.
Yeah. And actual damages could be, for instance, if you paid them less than what you had people making in that position or something, or if you set their pay inappropriately based on past pay information and in theory what they're arguing they could have made. So. All right, so just general takeaways. Don't ask for pay history. Remove that question from your application. Make sure you train your hiring managers on the fact that they should not be asking these inquiries. And if the applicant during a conversation brings it up, they need to very quickly document that it was the applicant that brought it up, not the employer. And try to have talking points for redirecting that conversation, because really the law wants you to only discuss and negotiate pay after a valid offer of employment with an initial offer for pay has been made. Other options, we've tried to think of some creative options, especially for if you think about certain positions, right? Like your executive director or certain senior level positions where maybe you do have a large gap between what an entry-level frontline worker is making versus your executive director. And so if you're replacing the executive director or hiring a senior candidate or filling a senior position, if you post that range and you're a nonprofit and you might have questions from your donors about how much you're paying those senior positions. You might have questions from the subordinate employees that are now going to know exactly what range their supervisor or their boss makes. So this is going to force you to maybe have less of a step between each of those positions. So creative ways we've tried to work with some clients over the last few weeks on what they're going to do for certain positions is, okay, can you do a ghost posting? It could potentially still violate the law. We don't have any precedent on it yet, but a ghost posting, in my opinion, would be you hire a third-party company to, like a recruiting company in your industry, to post the position. They post the job duties, the pay range, the type of employer, and the location, but they exclude the name of the employer. People might be able to figure it out. And you are like actively looking for a loophole, right? But that's a potential option. Using recruiters and headhunters for certain strategic positions might be helpful as well. The danger there is you might miss out on some really good internal candidates who maybe wanted to apply or had some experience, or who may say, wait a minute, I didn't get an opportunity. I never saw a posting, never got an opportunity to apply. I will say a lot of our clients have very inflexible policies with regard to job postings, such that before any job position is filled, they have to post it internally for 10 days, then post it externally, then they have to do all this stuff. Get rid of all those policies. Give yourself more flexibility. The law is already going to reduce your flexibility. So try to, you're not required by law to post things internally first and then do this and that. So try to give yourself more flexibility by revising your policies. And then another thing to think about long-term is promoting from within before you look external. That way you don't have to post. If you just promote somebody and say, man, Alex is doing a great job. He should we're going to give him this next level position. Try some creative routes of offering some cross training and shadow periods or transition periods. Put someone in a particular position under a trial period. You might miss out on some great external candidates, but this is a way if you really couldn't post the range for whatever reason. And if you guys think of other creative ways, feel free to reach out to us. We're obviously navigating this as well with some clients. So.
All right, so we'll try to pick up the pace here. I think we're pretty close to running out of time. So another big piece of legislation from 2026, it is Virginia's paid sick leave. It requires all employers, private and public, to offer paid sick leave. It's a simple calculation for accrual and the maximum amount of sick leave under the law. So employees are going to accrue paid sick leave at a rate of 1 hour for every 30 hours worked, up to 48 hours a year. That 40 hours is allowed to accrue over year to year, but employers are allowed to restrict the amount of paid sick leave that's offered under this law up to 40 a year. Another quick note on this too, a lot of our clients already offer certain sick leave, vacation leave, PTO in general. But we do see quite often that temporary seasonal workers, potentially interns, aren't usually covered by the employee's paid sick leave or vacation leave PTO policy. Under the law, it does not discriminate against, temporary workers, part-time workers, seasonal workers. All employees are going to be allowed to accrue 1 hour for every 30 hours worked of paid sick leave. And just a quick note on what paid sick leave is going to cover under the law. It's always going to cover, any sort of medical appointments, being sick, having an illness, a surgery. It also is going to cover incidents of domestic abuse, or stalking, or anything along sexual assault. And if you have an employee or their family member who is a victim of one of those acts, they're going to be allowed under the law to use their paid sick leave to attend counseling, to get legal services, to potentially relocate. So that's a little more expansive than what most individuals think of sick leave. And on that note as well, one of the big aspects of the legislation is that if you have a current PTO policy that's as generous or more generous than the 1 hour for every 30 hours worked, you don't have to add any additional leave under your policy. And another note on that too, we have a lot of clients who sometimes bifurcate between vacation leave and sick leave. If you have that as a general practice, you could certainly, the way you would calculate to see whether or not you're already in compliance with the law would be, if employees already accrue 20 hours of sick leave and then 30 hours of general vacation leave that they can use for any purpose, then as long as your sick leave includes the domestic abuse related stuff, then you should be in compliance, because they would be having 50 hours of total leave across the board. As long, again, you would have to make sure their accrual is also at the same level. But, certainly, ideally, we tried to work with our clients to make minor revisions to their PTO policies to make sure that they are in compliance. It's really a case-by-case basis. There are a lot of clients who have very complicated PTO policies and they split it up based on different purposes. So sometimes you're going to have a separate paid sick leave that's in compliance with Virginia law. But, just keeping that in mind, I think is important. And just a quick note on the effective dates. So if your organization has 50 or more employees, then by July 1st, 2027, employees are going to be allowed to accrue paid sick leave. And then January 1st, 2028 for employers between 25 and 49. And then 2029 for employers with less than 24 employees.
And I just saw a note from in the chat that, does this apply to part-time employees? The answer is yes, it applies to most part-time employees as well. So if you've got someone who's working, 30 hours a week or 25 hours a week, and they don't normally accrue sick leave, then you are probably going to have to revise your policy a little bit. There are some exceptions for certain types of employers or certain positions, like a nurse as needed. There's some very kind of express positions, but generally speaking, yeah, it would be kind of for anytime someone works 1 hour for every 30 hours worked, whether they work that over a pay period or 2 pay periods, they're going to get the accrual. So what if another question is, what if our policy is only PTO? You are perfectly fine to keep it as just PTO if you offer at least the minimum leave allowed in the law. So you can still have it be PTO as long as either they accrue it 1 hour for every 30 hours worked, or if you go ahead and give them the full 40 hours front loaded at the beginning of the year. So that's another option as well. You might have to change if you have PTO and you say, for instance, like you've got to use your PTO in 4-hour increments. You may have to revise that to allow them to use it in smaller increments. Generally speaking, the law says for as small, they can use it for as small of an increment as they can use other leave. So like if you allow FMLA leave in a 1-hour increment, then you're looking at reducing the increment here as well. So you might have to revise your current PTO policy, but it's a good idea if you're looking at revising your handbook this year to go ahead and start making these changes, so you're proactively getting ahead of your phase-in timeline.
And just another quick note on when you're revising your policies. Under the law, if the paid sick leave is being taken for less than 3 days, pretty lax requirements on verification and notice requirements. Employees are only required to provide reasonable notice with necessary, and employees are restricted from seeking health-related information or information regarding domestic abuse if the leave is less than 3 days. Once leave under this law is taken for more than 3 days, then you can seek verification. The law does not define to what extent you can seek verification. And so that's just a quick note. And then I'll go quickly through these questions as well. Somebody asked, is there a waiting period before accrual begins for new hires? Under the law, no. It begins automatically. I guess you can look at the 30 hours as a very short accrual period. And did I hear you say it also applies to seasonal employees? Our interpretation of the law is that it does. It applies to any employee who works for an employer. So that would include seasonal, temporary, anything along those lines. And then another question, we have a 15 to 20 hour week part-time accounting assistant. Should she get PTO accrual? Under the law, she doesn't necessarily need to get PTO accrual, but she would need to receive paid sick leave in accordance with the law. And if she's working 15 to 20 hours a week, then her accrual, she'd gain 1 hour of paid sick leave if she's working 15 hours a week every 2 weeks. Is the carryover required? My understanding is that carryover is required. Payout is not required, by the way. I don't know if anybody's asked that yet. But
like if you have 30 hours at the end of your calendar year, the company's not required to pay that out. But you do have to allow at least carryover, I believe, of up to 40 hours into the next year, unless you go ahead and just front load it. So, in theory, right, everyone should always get that 40-hour bank to start the year off.
And then this is an interesting one. Does this apply to independent contractors? My understanding is that it would not, because they wouldn't be defined as an employee. They'd be defined as an independent contractor. But again, if you're using I-99 contractors, just be aware that we see a lot of clients trip over themselves when they hire independent contractors. And,
well, they call them 1099 employees, but that is an oxymoron because there's no such thing as a 1099 employee. You either have a W-2 employee or you have a 1099 contractor. And you really, if you're contracting with someone individually, it's just a one person, you run a really high risk of misclassifying them as a contractor. So before you don't provide them some sort of, before you keep retaining them, you want to be careful not to have them misclassified as a contractor. Generally, you're not supposed to have someone classified as a 1099 contractor for more than 6 months. It's just a general best practice. because at that point, it looks like you're trying to avoid having to pay them benefits and give them other like things like healthcare and comply with other employee threshold laws as well. So depending on how you have them set up, I'd look at that one to see, do we have this person misclassified? Do we need to move them to W-2? And do we need to start allowing them PTO accrual or front load them some PTO?
And yeah, and just to have a conclusion, because I don't know if we actually answered your question. If they are truly an independent contractor, then you would not be required to provide them paid sick leave under law.
Esther, I know we have 2 more slides on the new laws, so we're happy to finish those up. But I don't want to go over our time because I know you guys have a lot of other stuff as well. So you just let us know when you're.
Yeah, I mean, yeah, if you want to wrap the 2 slides up, and then I mean, if you want to give kind of a quick overview of your EEOC updates, I mean, I think
Sure.
some of the information is really good in there. So yeah,
Sure.
go
Okay.
ahead.
Cool.
Well,
All right. So moving to the next big one, paid family and medical leave. Virginia's joining a couple other states that already have this in place. You can look at it as your standard FMLA leave, but it is now paid. It's not paid directly by the employer. Instead, similar to how unemployment gets collected or workers' comp gets collected throughout the state, there'll be a fund created specifically to pay out employees a certain percentage of their salary while they're on family and medical leave. It's going to be paid by a tax that's shared by employers and employees. And there's 2 levels to that tax. I think if you are a employer with, I think it's maybe less than 50 employees, then I'm almost sure that you might be able to put that whole tax onto your employees. I would have to double check that, but just keep in mind that depending on your size, will depend on how much of a burden you will have to share with increase or submitting money to the fund. So this is also going to be administered by the VEC, and what we've seen in other states that have passed paid family and medical leave, it's quite a complex system, and it's going to be run through the VEC, and the VEC at some point, we don't have the date yet, is expected to pass certain regulations. And if it's like other states across the US, VEC will probably create a website, will create a bunch of helpful things that will allow employers to give them, very definite steps on how to go about this. If we don't have any information on how this is going to function, but just thinking about how I've seen it in other states, typically you would be required as an employer to create some sort of account with VEC that connects you to the program. And then from there, you typically assign some sort of administrator, probably an HR personnel who would be responsible for communicating with VEC when they receive a claim from one of your employees. And the employee rather than the employer will be the one who's responsible for submitting for paid family and medical leave. Once we get to that point, they would submit it with VEC. VEC would be the decision maker whether or not to grant any sort of paid family and medical leave, and then also the amount that is granted to them. VEC, like with unemployment, will most likely request information from employers, and that's why you'll have an online portal in which you can communicate with VEC. So just a couple key dates. This is going to take a while to come about. So October 1st, 2027, VEC is going to set the employer contribution rate, and that's going to be the amount that employers are required to contribute to this fund. And then April 1st, 2028, both employees and employers will begin contributing to the program. And just a quick note on that, as I said earlier, it's going to function like workers' comp insurance or unemployment insurance as a tax. So you could probably work with your payroll if you use ADP or anything along those lines. They'll probably have an ability to add that tax automatically if you're doing payroll through a third-party company. And then December 1st, 2028, that's the big date when employees are going to be able to take paid leave under the statute. And then one more quick note, any leave under this any paid leave under Virginia's family and medical leave is going to run concurrently with the federal FMLA leave. So employers aren't going to be getting 24 weeks of leave now, of protected leave. It's still going to be the 12.
All right, so final new law. This one passed somewhat without a lot of media attention, but basically Virginia has a new law that says you cannot threaten an employee based on their immigration status or the immigration status of their family. So this is really going at your, bad faith employers who are saying, well, you're going to take this pay or work this job, or you better show up on this date and do this or work for free. Otherwise, I'm going to, call ICE on you and stuff like that. Contrary to, I'll just quickly summarize, EEOC, the Equal Employment Opportunity Commission on Friday released their new strategic plan. And so these are basically the things that the EEOC is going to be looking at and prioritizing its resources on. Some of those key things are they're looking at employers who discriminate against white workers in favor of visa holders. They're looking at, they haven't brought a single LGBTQ related charge, so a charge based on sexual orientation, gender identity. They haven't brought a single one under the Trump administration. They're actually looking at prioritizing in their plan the right of an employer to look at sex as binary, as birth-born male and birth-born female. We would caution you to ever follow something like that because there is Supreme Court case law and statutory case law that the Supreme Court was very clear that non-discrimination on the basis of sex includes non-discrimination on the basis of sexual orientation and gender identity. So to follow the EEOC, while you may, it is guidance, it is not the law. And if you do follow that, you could still face a lawsuit by following something like that. And then finally, you've got, they're looking at employers who have unlawful DEI programs. And unlawful DEI is generally an employer who maybe has a quota or an intent to put women, people of color, certain people in certain positions. And so, totally fine to have DEI related programs. That is lawful. You just have to be careful about how you go about it. So with that, we want to thank you guys for our time. If you guys have any follow-up questions, feel free to reach out to us. I know it's a lot of information in 45 minutes, but please don't hesitate to reach out as you kind of navigate through these things.
Okay, and folks will be sharing the slides afterwards. So thank you, Leah and Alex. Wonderful. Thank you so much.
Thank you. Nice meeting everybody.
So now we are at the portion where we are going to do the report review for the Moving Towards Equity report. And so I just want to begin with the original mission. This applied in our 2024 report, and we haven't changed it for our 2026. So just our focus here is helping RVA nonprofits understand where they are positioned in the local market with their pay, their benefits, and their pay practices, helping you all make impactful board presentations and educating your funders, and then helping you recruit and retain your staff. And so those are really the core focus, and we have brought that into the 2026 report. So how to read the report? So some reading suggestions. First, I would start high level. I mean, I understand the report is 104 pages, and so that just data point in itself can feel somewhat overwhelming. And so I suggest you dive in first by going to the employer takeaways, which is a one-pager at the end of each topic section. And go ahead and just read through what key takeaways were for each of those sections. Wood Rogers did a great legal update, so I would dive kind of into that next. And then I would go into our article called The Conversation Ahead, and I'll talk a little bit more about that in a second. But that was pulled both from our pay equity survey that we did with your staff as well as the general survey. And then lastly, I would kind of wrap up your high level review, just looking at the table of contents and seeing all the topics that are gone into and what might be curious for you, what might be an area that resonates or you want to learn more about. And then I'm might suggest you just set it aside for a minute, maybe a day or two, just kind of let that sink in and then come back in and begin to kind of go through each section or, as needed with the various charts. Some companion tools that are in the report that will help you understand the charts better are the How to Use the Report Salary Data article, and it's something that I'm going to slightly walk you through today. We're going to do a compensation analysis together. And then there is also survey and participation overviews, which will help you understand how to read the data. And then a guide specifically to our salary by position chart. So do lean on those companions. They will help you along. All right, so let's start with some high-level takeaways or things that we felt were significant, even surprised us slightly. So overall, I think the most significant data point that we saw was there was a 32.8% decline in merit increases. And so we saw a really huge pullback in providing merit increases. And where we saw some shift to was in employers giving simply across the board increases at a certain percentage or leaning into just cost of living adjustments. So we do see some constraint in the approach around merit. We also saw any merit increases that were given above the median amount. We saw once you got past that median percentage increase, so the higher bonuses, the higher merit increases, we saw a pretty sharp decline in the amount of those bonuses. And overall, while we found incentive structures in our nonprofit pay, they are somewhat limited and often concentrated towards the top. And then overall, just the median for the merit and the bonus was down by 1%. So we do see some constraints, some reservation happening in 2025. So some areas where we identified as potential competitive opportunities for you as an employer, if you are looking to stand out in the market, as we saw that employers many times wait until the 5th year to increase their employees' time off accrual. So potentially you could be more competitive by making those increases earlier, such as between the 1st and 3rd year. A lot of employers are not offering sabbatical leave to their leadership. So that is definitely somewhere where you could stand out and offer as a negotiating tool. And then while we found a really consistent and commitment to annual reviews, we didn't see much beyond that. So if you have a great training program and you have the capacity to offer more frequent feedback, whether that be on a quarterly or monthly basis, for your entry to mid-level folks, that could make you really stand out. That as an employer, we are an employer, we're a place where you could grow and learn. And then hybrid schedules was definitely a curiosity going into this year's survey because we are some years out of the pandemic. So has that been retained? And we found out, yes, it still remains important that employers do value and employees value the flexible schedule that was achieved through hybrid. The last kind of note is, again, going back to our conversation ahead article, encourage you to read it, but really job security, concerns around job security within your staff, shown through our pay equity survey, are prevalent. And 42% of the respondents felt that they were concerned or very concerned about their job security in the upcoming year. We also found that through some of that feedback that any resilience that staff have towards kind of managing all these shifts around public funding or potential shifts within the structure of the organization, resilience is connected to workforce experience. So, it's not just being transparent about the communication, it is coupling things that support workforce experience overall. So again, want to encourage you to take some time for that. All right, so our next step, we are going to do a compensation analysis together today. And I've kept it very simple intentionally to just walk you through the process. Hope it'll be a really good refresher for everyone here today. So I have chosen an admin assistant. And so we just have a scenario here that I'm presenting. So this particular admin assistant, the role was restructured from an office manager role. And now the HR manager has been asked to go and find a competitive salary. So the first thing you want to do is understand how your compensation philosophy as an organization connects to a certain pay percentile, because that's what's contained within our charts. So organizations approach this differently. Some organizations only lead towards one pay percentile and try to set pay around that, the midpoint of pay around that pay percentile. Others use a range of pay percentiles. So they decide we are going to pay between the 25th and the 50th pay percentile. Again, for this particular scenario, we are going to keep things simple. And so we are going to go to our 50th or a median percentile, which we many times refer to as at market pay. All right, so we know our pay percentile, then we're going to go ahead and we're going to pull the revised job description that we have that we're using internally for this role. And we're going to go to the salary by position chart for this particular role. So within the Moving Towards Equity report. And at the end of the salary chart, there is a job summary. And it overviews, and I've kind of put it here in the background, the job duties, qualifications, the typical reporting structure, potential alternative titles. And we're going to take that job summary and we're going to take our internal job description and we're going to use the highly technical process of highlighting. So just highlighting through, whether that be hot pink, hot green, yellow, whatever color works, but just going through and seeing where there's a potential match between our job summary and our job description. And so the goal is to get to an 80% match, but it's not a perfect formula. So, if it comes back substantially yellow, you're probably in a good space. I do go into the report explaining how to use the salary data, some approaches that are a bit more sophisticated, a bit more mathematical, but for most cases, this will do you. All right, so now I have my job match. I know for sure that it matches my job summary. I have my pay percentile. And then to complete out the pay profile, before I go and use the chart, I want to identify my service area, my annual revenue, and my full-time employee account. And then I go to the chart itself and I simply use what I've identified in my pay profile to identify the relevant wages. And so here for this particular role, we see wages from $23.50 all the way up to $25.73 per hour. And so those are my wage data points that I'm using from the Moving Towards Equity report. Now, I don't want to stop here because we do have secondary data that we should bring in. And we have a rule called the 3 sources rule. So when we want to ensure accurate, balanced, and reliable data, we need to take a blended approach. And so for this particular position, I am bringing in data from the Bureau of Labor Statistics. I'm also going to be using wages that are posted on Indeed, and I'm going to bring that all together to have sufficient data to make an analysis. When you are looking for job postings, one thing to keep in mind is the difference between business competition and talent competition. So business competition is your like organizations to whom you compete with many times for clients or customers. So here I have all the cereal brands and they are business competitors. But when you're looking for talent, you need to many times extend the net beyond your business competition into who you're competing with for talent. And for this particular title of admin assistant, that is very relevant because an admin assistant can work in nonprofit or for-profit. They can work across multiple industries. So it's beyond what is cereal to what is everything that we can have for breakfast, right? It's just a bigger analysis. One little thing I want to kind of point out here is I asked AI to help me make this pictogram for you. And AI thinks that we have burgers and fries for breakfast. And so someone recently asked me, can I use AI to do my compensation analysis? I think you can use it definitely as a thought partner and as a sounding board. But you do need your solid resources, and you do need a certain level of kind of comfort and competency. You need to be able to see the burgers and fries in the picture and know that we don't typically have that for breakfast, right? So, so just a little bit of a public service announcement around AI that was just kind of a fun opportunity that happened through this mistake for this pictogram. All right, so I am having a talent competition approach towards analyzing this particular role. So you see I've gone out to different types of companies in order to find relevant wages. But where I've stayed narrow is the title set, the duties and responsibilities. And for this particular position, because I am focused on looking entry to mid-level, I do want to focus in on certain years of experience. So I have placed emphasis on that in my analysis and ensure that I've stayed within the brackets I wanted there. One thing to note, watch out for those senior or junior designations. That could be a completely different pay scale. And so it may not be relevant data to bring into your set. All right, I found 5 job descriptions that have given me wage data, both at the bottom and the top of the range. I've kind of laid everything out for me to see. And then I'm gonna look and see if just within the job postings that I found, what is the trend? And I'm gonna try to identify if I have any outliers. So that is an amount that is significantly off trend. And for this particular data set, I am going to remove job 3 as an outlier. It's just significantly below the others where they are trending at in the chart. And then another thing, where again, imbalance. So it is kind of a dance of being broad enough, but yet being narrow in certain aspects. I do want to try to stay as local as possible. And so all of these jobs were offered in the Richmond, Virginia area. All right, I just wanted to show you what data from the Bureau of Labor Statistics looks like, and to show you that they also give the data within pay percentiles. And so this is what I'll pull from that particular source. All right, I bring it all together, and I usually like to identify my lowest and my highest within my wage data set. And for this particular role, kind of the trend I'm seeing is a pay range between $23 per hour to $28 per hour. And that is what I'm going to post. Now you do, of course, it's not an isolated process, right? You do need to be able to reconcile that with your budget, but something also emphasized by the Wood Rogers Group, and I'm going to emphasize it here, is you need to see how that wage coming into your organization will impact internal equity. So you're not just looking at similarly situated titles and roles, right? That is definitely important. But you want to also look one level above and one level below, because you want to be able to ensure that as you bring that new role into the organization, that they have room to grow into the next level potentially, right? And that there's not too much wage compression between the various levels. And so here, the data points that you're looking at are our manager and director. And this is just the 50th pay percentile, and it is pulled directly from our Moving Towards Equity report. So it just gives back the annual amount at 50th percentile pay. And you can see between our managers and directors, and within the various kind of subsets of groups, there is room to grow, right? So we do have a good amount of space between our manager level and those coming in at our director level, as well as kind of all the way to the top. And so I would say, what we found in the report, I did the same thing in the 2024 report, but I do see good pay equity within our, kind of nonprofit ecosystem. I do see a focus around that, and I think this kind of is evidenced here. But when you're doing compensation analysis for an individual position, you do want to check this. And I think kind of coming into the new pay transparency law, if you haven't done a pay equity overall analysis of your organization, this would be a key time to do that and see where maybe you have some risk. Because again, you cannot penalize or discipline your staff for talking about their salaries, so they are able to do that. All right, so my wage range that I selected is, vibes with my internal equity and vibes with my budget. And so I go ahead and I post it and I hire someone that has 4 years of experience, because that's a little bit at the top of my experience range. I go ahead and I decide to give them a wage between the midpoint and the maximum. And I make an offer, they accept, everything is great. And so some parameters that you can use to decide where you will set the wage between the minimum, mid, and max point, I've kind of shown here. So from those that are kind of new to the role or have a lower proficiency level to where we see a higher proficiency and more experience, you can move up and down between your min and your max. Okay. All right, and something to keep in mind, comp pay is important. Yes, it's key, but just remember to have a holistic approach when folks come into the organization. And so that is making sure that you're talking to them about what are their career aspirations and incorporating that in early as possible. A good opportunity to do this and to create a career roadmap discussion is through your 90-day performance review for new hire. Potentially. And so for this particular position, there was an interest in events management. And so the supervisor and the new hire identified some opportunities to grow those skills. And then within your first year of employment, best practice is to have 8 touch points of contact with that new hire, where you're having kind of a meaningful intention around that person's work experience, right? And we just talked about how work experience ties into resiliency in the workforce. And so from the new hire welcome to some birthday fund to some opportunities to develop some skills to even that 1-year service recognition or a spot bonus for a project well done. But if you are thinking about recognition this year, 8 touch points is a really great place to kind of start and identify, okay, what do we have in place that gets us there already? And then what can we maybe add in the mix? All right, I want to kind of wrap that first compensation analysis up, but I also want to talk to you about the importance of workforce segmentation. So many employers, in order to stay competitive, and especially in more constrained markets such as we're coming into, it seems now, is they will identify and segment out certain groups within their organization in which they need to pay more competitively. So say they have a certain group that they pay at the 75th percentile, and then maybe their executive and their office admin, they pay at the 50th percentile. A lot of times for nonprofits, this higher, more competitive pay segmentation we see at the entry level. We see in positions where there's a lot of turnover, and so it is a way to kind of reduce that turnover and help with retention. Another way or how you can kind of extend the concept of workforce segmentation is into the way that you approach your compensation analysis. So for many of your roles, the baseline 3 sources rule will be a sufficient approach, and it comes many times with a lot of free and reliable data. But there are other roles within your organization where you could really miss out if you don't take a more competitive approach to your analysis. And that many times means paying for data or paying for a consultant to kind of support you in that compensation analysis. So I'm going to kind of show you that as one more scenario just to kind of wrap things up. But I'm going to bring in a more elevated role of an executive director. This particular executive director has very typical responsibilities for the role. We're looking for someone with a master's degree in education and someone who has significant nonprofit leadership experience, and we've been asked to establish a salary. So just like we did for the admin assistant, we're going to start by creating our pay profile and bringing in all those kind of various points of our identity and ensuring that we have that good job match and an understanding of where we set our pay percentile. And then we're going to bring that into the chart to identify what we consider to be the relevant wages from the Moving Towards Equity report. But other data sources that we could bring in would be 990 data for this role. We could pay for other surveys and their data to review that. But I wouldn't just stop at 3. This is a role that I would typically bring in 5 or 6 sources of data, right? And with the 990 analysis, it's a little bit like looking at job postings, right? I'm looking at multiple organizations and sometimes across the state of Virginia, right? Within the Hampton Roads or the Charlottesville. It's wherever my candidates can go. I do want to take still a talent competition approach when thinking through that data. All right, last little reminder is that data ages. And when it ages, we do have a way of correcting it, or we call it aging our data. And so you can use the employee cost index to do this, and it's applying a percentage on that older data point. But once data is past 2 years, we kind of call it quits for that data. So just note that that is an industry standard, just kind of a friendly reminder as you start to do all this great compensation analysis yourself. Okay, I'm going to open it up for Q&A. I also just want to thank so much our funders, the Bob and Anna Lou Shaberg Foundation, for funding today's webinar and bringing in our attorneys from Wood Rogers also to talk us through some of the legal updates. So any questions? You can just put it in the chat. Okay. Well, I hope, oh, there we go. Okay, no questions. Thank you. Thank you so much, everybody. Let's see if we got a question from Sue. Thank you, Alex. Thank you, Leah. Great job.
Thank you, guys.
Yes, so employees can talk to other employees about their salaries. They are able to do this, and you are not able to discipline them. Alex, do you want to speak to that?
Yeah, that's correct. That's actually been the law for a long time, that employees are freely able to discuss their salaries, discuss inequities between them. It falls within protected activity, so other things regarding working conditions and employee benefits or what somebody favoritism between one employee to another would certainly be covered as protected activity, and that includes salaries as well.
That can cause a lot of discord. Yeah. So I think that especially with this new pay equity law, right, where you're going to have to post your wages, that'll be for your high level as well as your mid and entry level. And so if you haven't done a pay equity analysis in a while, that is a good place to start. I've gotten a lot of questions about, hey, we're moving through that process right now, but what do we do? Because this law is going into effect in 3 weeks. And so some of what I advised was just, do the comp analysis for the positions that you post. And then when you do finish your pay equity study, come into it with your staff and have a lot of great communication around it.
Yeah, I agree. I mean, this is by increasing, kind of exposure to what certain people in certain positions get paid. It is going to cause a lot of discourse. overall for society's good, it's probably good discourse, but, I think employers will just need to manage that. And the best way you can do that is ensuring that you don't have any necessarily egregious pay inequities currently in place. Like if you have a 10-year employee who's getting paid, X amount, and then you're posting for their exact same position, entry level position, and that person's getting paid more, then that might be something that needs to be trued up before you go public with a job posting.
Hey,
I see that
Alex,
there's
do you see Fanny's question?
I do, yeah. I'm
About-
about to read it out. We don't ask for salary history, but we do communicate this is our anticipated salary range and confirm that they've read and understood that. Will that continue to address salary? We will continue to address salary in this way moving forward. That's completely appropriate. That rather than asking a prospective employee what their previous salary was, you're providing them with an understanding that this is our range and this is what you are anticipated should you get a job here, which is exactly what the pay transparency law is supposed to do anyways.
And then where do salaries get posted? Everywhere. Yeah. So if you do an internal, I would post it there, right? If
Yep.
you have it on your website, post it there, any third party that you post. So a good approach is if you have an applicant tracking system that you have all your postings from that base post that includes that salary range.
Yeah, and I would say the only creative way to go about that, and we touched on it, is if you were to use a recruiter and you're just providing the recruiter with certain information and then they're reaching out to certain prospective employees. Again, we can't say with full certainty that that will not be viewed as trying to hide behind the pay transparency law, but that is just one creative solution that we've come up with.
I think they're going to come for us, Alex, and figure something out.
I know.
I'm just waiting.
Yeah.
All right. Well, thank you, folks. Yeah, let's hop off. Thank you so much, Alex, for staying on. That was kind of lucky.
Yeah.
All right. We're going to end today's event. Thanks so much.
Thank you, guys.